Hi everyone, it's Lorie Brown from empowerednurses.org and yournurseattorney.com, and I'm here with a very special guest today, Ryan Fox. And Ryan is an attorney with Fox, Williams & Sink here in Indianapolis. So Ryan, would you like to introduce yourself?
Sure, I'm with Fox, Williams & Sink, and we primarily represent individuals with claims of unlawful termination in the state of Indiana. Normally that would be claims of discrimination or unlawful retaliation. We also do wage claims or overtime claims, as well as claims involving leave such as family medical leave.
Yeah, that's a big issue in nursing. I'm going to jump ahead of our agenda here, but a big issue in nursing is nurses don't get their breaks. And I know there's a lawsuit going on in Texas with nurses who aren't paid for their breaks and they're not getting their breaks. What are your thoughts on that as far as is that legal and what can a nurse do about that?
Well, generally speaking, if the employer knows you're working through your break and you're not being compensated for it, then that could lead to potential wage claims. There is some in terms of the individual. It's important to notify the correct supervisors in most circumstances that if you are not getting your breaks or are being forced to work through your breaks, that they have knowledge of that. The issues in terms of the time worked is important in nursing, and also breaks, as you know, Lorie, are needed if you are a nurse. So complaining about not receiving the proper pay, especially with regards to overtime, can lead to a potential claim and can lead to protections from unlawful retaliation.
Great. And again, remember Ryan's comments are from his experience here in Indiana. So what we're going to do is kind of walk you through a job scenario, different points of time in an employment situation, and discuss things that can happen during that time. So our first topic is pre-employment. And if you have a pre-employment physical, be prepared to take a drug screen. If you have anything in your system, I know that hospitals, they will give you a pass if you have a valid prescription for it. But just be careful about that. Ryan, have you ever worked with nurses who had a positive drug screen and didn't get to continue working?
Well, I think the most important thing is that with regards to drug screens, I think sometimes that may happen to individuals is something pops up on the drug screen that they don't have a prescription for. I mean, that is a problem. Employers only need a legitimate, non-discriminatory reason to terminate or decide not to hire someone. So with regards to the pre-application process, I think it's very important to tell the truth. Even in hindsight, after you get a job, if it is later discovered by your employer that you were not truthful in the information that you submitted, for instance on an application, that would give them a legitimate, non-discriminatory, non-retaliatory reason to terminate your employment.
Yeah, it's really important for nurses to be honest on your employment application. Now, I know some nurses who, they see the wind, it's blowing, that they're going to lose their job, so they go out, they get another job, they get the other job, and then they're terminated from the one they already have. And I always believe honesty is the best policy. You never want to be in a situation where your employer doesn't know the whole truth about what happened. So you can't conveniently omit a job on your job application because that's fraud and material misrepresentation. But I always suggest, and I don't know what are your thoughts, I suggest that if they've been terminated, to write that they've been terminated, and when they ask for a reason, just say we'll discuss in the interview. What are your thoughts?
Yeah, there is no magic formula. Many times I think that an individual has to kind of judge for themselves of what's appropriate. If you can, but as Lorie said, I think if you can get that and then explain it to someone and get to that interview, that's really the primary goal. Hopefully if you get the interview, then they know what kind of person you are, what kind of worker you would be, and what kind of nurse you would be for that particular medical facility.
Great, yeah, definitely. I always say it's who you know, and it's not like in the old, it used to be that there was no internet and you couldn't do these applications online. You had to make relationships with people, and that's how you were able to get in the door and get interviews. And now it's a little different. But I think if you've got something in your background that doing it the old-fashioned way, who do you know? Who can help you get in the door really helps.
Mm-hmm. I agree.
Now, is there such a thing as like blackballing, or you know what I mean, where a previous employer will tell somebody not to hire you?
That's very rare that an employer is going to, so if you go and apply for a job and you don't get it, a lot of nurses believe that, well, it's because this ex-employer was going behind my back and saying things that were not true. But from my viewpoint, those can be very hard to prove because you basically need that future or prospective employer to tell you, oh, employer X said this, and then you have to prove that it's untrue. They usually don't want to get involved. I would say the majority of employers, especially nowadays, do give neutral references, but I can't say that it's unheard of that an employer or they talk to an individual that maybe is not used to giving references and says things that does interfere with that potential future employment of their ex-employee. The tough part is to have a witness that says, this is the reason we didn't hire you based upon this false or defamatory statement. And it's very difficult for nurses to protect themselves because it's tough from my vantage point to prove that they weren't hired and for someone to come forward and give that information. That's why I think it is always important, I think, for nurses to know if they do leave employment, what the employer's policy is with regards to if they are to be contacted by future employers.
Yeah, and the same is true if you've had licensed discipline. You know, the nurse automatically assumes they didn't get the job because of previous discipline, but you don't know that for sure. And unfortunately, discipline is permanent, and there's nothing to do about it in most states. So, but if you have discipline, just be honest and upfront with them. It was a long time ago, and explain what happened. Okay, so now we're going to move on to, okay, you've got this job, and things go well initially. You have that honeymoon phase, and then things all of a sudden go south, and you get a write-up or some kind of discipline. So what do you do about it? Ryan, how would you suggest if a nurse gets written up, how would they handle it?
Well, I think the first thing is if you're written up, sometimes they'll have you sign a form, and that form doesn't say that you agree with what's being on it, but they're having you sign it because that they can show that they actually gave it to you. In the state of Indiana, we're known what's called an at-will employment state. So being treated unfairly or being treated unpoorly is not necessarily illegal. So one of the things, the first thing that I look for if a nurse is being written up or there's an actual adverse employment action taken, like a suspension, is the first question I'm going to ask is A, did the nurse do this? And was it warranted? And then the second one is, have other nurses committed similar acts, and how are they different from you? Because unless you have a written employment contract, which many nurses do not have, that gives you extra protection, then the avenue is to look at federal law here in the state of Indiana that protects discrimination from nurses on the basis of age or race or gender or national origin or disability, or if they're being sexually harassed at work or being retaliated against. So I want to know, if someone calls me, how are the other nurses being treated in similar circumstances? Were they not written up? And then the next entry is there a difference between the nurse that has called me, that has been written up, and these others that aren't or receive less? Is this original nurse that has called me, is she older, in her 50s, and all these young nurses commit way more egregious acts, but nothing's happening to them? That could point to maybe some discrimination. And you kind of go down that line. Because here in Indiana, there's no, unfortunately, bad employer rule, or there's no law that says an employer has to be nice all the time. So you have to fit every case into the mold of normally a discrimination or something under federal law, and under few circumstances, Indiana state common law.
So if you get written up, do you recommend that they write, I disagree with this, or do you recommend that they write their side of the story on the form, or what do you recommend?
I usually take it on a case-by-case basis.
Okay.
So it really is, I also tend to look at what the policies are of the employer. Some employers have policies that you can actually go through a grievance procedure, and some of them, I have seen some of those been taken seriously. The also thing, especially when it comes to nurses, and if there's any discipline involved, I tell them to call Lorie. Because that is when you start talking about the nursing board, and you start talking about things with regards to your license, you need to talk to someone that knows and has knowledge of the ins and outs of what the nursing board looks at and how much of a threat it could come and impact, which I'm sure you can speak to more so than I can.
Yeah, the problem in Indiana is if you do receive a write-up or any type of discipline, it could even be regarding attendance. On the license renewal, they ask the question, have you been reprimanded, disciplined, or terminated in your capacity as a healthcare provider? And you have to answer yes and explain the circumstances. You cannot conveniently omit that. And if you do, if you're under investigation for anything, every time you omitted a discipline, they're going to have a separate count on the administrative complaint saying that you committed fraud and material misrepresentation on your license renewal by not disclosing that information. So that's why, discipline and write-ups are really important. Even educational teachings, if they pull you aside and say, hey, I've got to have a talk with you about your documentation in this case, that is still a reprimand, and you need to disclose that. Anything in your employment file needs to be disclosed because they will get those. Now we're going to talk about administrative leaves or suspensions pending investigation. So Ryan, what do you suggest if somebody has been placed on administrative leave or suspended?
Well, they don't really have a choice in it if you're based on administrative leave. Usually at that point, I think it's always good to call an attorney if you are suspended and pending termination to know what your rights are. One of the things I wanted to add that many times what happens in some cases is you have a rogue supervisor of a nurse that is treating a nurse differently, maybe because of her race or because of her age, and you start seeing the paper trail start happening where they're starting to go through that progressive discipline process, and it's completely unwarranted and unjustified. One thing that an individual can do before it gets, if they truly believe that it's because of, let's say, age or race or gender, is they can go to HR and complain about that and ask for an investigation to take place. And under the federal law such as Title VII, it is unlawful for an employer to retaliate against an individual who complains or reports discrimination or harassment. But if the individual hasn't done that and they've already been suspended, then I think that is at the time that they need to pick up a phone and call an attorney to get some advice and to know what their rights are. And many times attorneys have bad news because a lot of individuals think they're covered and are protected under certain laws that they simply aren't. And although one may be able to prove that you're being treated unfairly, that does not correlate necessarily into unlawful treatment. So it's always good to know the good and the bad.
Yeah.
And bad news is sometimes what I deliver in consultations, but what individuals need to hear. Because with regards to employer's policy, if you are suspended, you need to understand what your rights are through that employer in terms of the grievance procedures as
Right.
well.
Mm-hmm.
But most importantly, as a nurse, you also need to, if it's a performance-related issue, as we've touched upon, you need to know how this could impact your license and thus your future career.
And my recommendation, if you think you're going to get fired, quit. And make sure they accept your resignation, because on every future job application, you are going to have to disclose that. So if you can resign versus getting terminated, that's better. However, if they do ask you, were you terminated or did you resign in lieu of termination, that's another question. And again, you've got to be honest about that. Go ahead.
Yeah, no, and I kind of look at it on a case-to-case basis.
Yeah.
I look at whether or not, if someone calls me and says immediately if I'm going to resign or not resign, I try to bring them in and talk to them so they understand what a forced resignation is, which could be an adverse employment action.
Right.
Whether completely just you resign out of the blue and that you really weren't going to get fired, then you don't really have an adverse employment action. So it's very case sensitive. So before, though, I think if you're deciding to quit because of the atmosphere or because of the environment, I think you should talk to a lawyer, and you should talk to someone that is proficient in nursing, like yourself, Lorie, that can kind of outline what could be the positives or negatives in terms of that course of action you take in terms of ending your employment relationship.
Yeah, definitely, because you don't want to put that on every future job application. So you had mentioned about age discrimination, and I wrote a blog this week. It was about mandatory overtime, and one nurse we got a comment that a nurse was 65 and was terminated, because she refused to do mandatory overtime. And the question was, well, how do you prove that? And my comment is going to be to talk to somebody like you, but what would you say about that?
Well, you normally, in any sort of adverse employment action, you have to, because they can terminate you normally for any reason.
Right.
Or no reason at all, or just because they don't like you. So, you know, my question is always going to come back to comparing yourself to the other individuals. For example, was a younger person in that, I guess, factual scenario or hypothetical, was a younger person forced to work overtime and that person refused, but she's not fired, yet this older person is. Well, that could be evidence of age discrimination. And you kind of always have to go through that with regards to any claim. That's not to say, though, that direct discriminatory comments don't happen and don't take place. In the climate that we live, it does occur. So nothing surprises me in terms of things that I've heard with regards to comments that are ageist or racist or sexist. But that does not occur as much as obviously discrimination that is more concealed and hidden, and that's where you get how are similarly situated employees treated.
You also talked about like retaliatory discharge. What is that?
Retaliatory discharge is if you engage in protected conduct under federal law, that it would be unlawful for them to terminate you for that complaint. And I think this is one of the things that happens with regards to people that I meet with after the fact is when I ask, well, did you ever complain about the treatment? And so they go to HR or they went to the supervisor and says, oh yeah, I complained, but they didn't say the magic words. Retaliation, you really have to say if you believe it, and if you believe the treatment was due to your race, age, sex, etc., one of those protected characteristics, then that can be unlawful. But what I do find sometimes, unfortunately, is people have gone and said, no, I just went and said, you know, Jane was being was mean to me, or Joe doesn't like me, and I wish, he would treat me better. You really need to make it, to put the onus on the employer to take prompt and corrective action, and if you don't report it correctly, then that's not necessarily protected activity.
Okay, so magic words there. And then what about, what happens then if you're terminated? Do you have any recourse, or what would you suggest?
Well, I think in terms of once you're terminated, you want to know what your rights are, and you want to know, and with regards to termination, there's deadlines, there's statute of limitations that you need to be aware of. It's not something that you can just sit by and think, well, maybe I'll do something next year. Normally, the course of action for discrimination cases is to file a charge of discrimination with the Equal Employment Opportunity Commission. And although there are some laws where you can go straight into court, like breach of contract for a state law claim or other things. But the first thing I think in terms of getting your ducks in a row is to contact the attorney in your specific state, knowing what laws may cover you. Sometimes at termination, you're also given a severance review. Normally those severance reviews are going to say consult with an attorney. That's what they say, and that's what you should do. You should take the time to at least know what you're releasing in those agreements. But I think it's important to act faster as soon as you're terminated, to know about your statute of limitations, and also to know what your rights are, and also sometimes to get a sense of, for yourself to make the best decision, to know all the options out there for you.
Okay, great. And then we already talked about finding a job after termination. You do have to disclose it and be honest with your future employer. You can't just magically leave it off. Okay, so now you said you've had a couple issues recently with regard to medical leave and absences, and what are those? Well,
I think the main thing with medical leave is when you start with an employer, you need to know what their policies are with regards to leave. There's certain federal laws that if there's enough employees, you're protected if you've been there long enough and have worked enough hours, that you could be protected under the Family Medical Leave Act, which guarantees up to 12 weeks of leave if you're otherwise qualified. But also, the law does not necessarily protect employees that have indefinite leave with no return to work date that can go on for months and months. That leave is not necessarily protected, even under the Americans with Disabilities Act, always, or obviously under the FMLA, which only allows 12 weeks. So with regards to medical leave, especially if you're on a medical leave of absence that is not covered under the FMLA, and you would have filled out that paperwork and gotten approval from your health provider and obviously the employer, then you may need to talk to an attorney to see what your rights are in terms of how long the leave can go on, knowing what your employer's policies are, knowing what to do in terms of calling in and reporting that you're following all the proper procedures. All of those are very tricky and need to be dealt with on a very individualized case-by-case basis.
Great, thank you. So we refer all our nurses to Ryan because he has, he understands nursing, and he has dealt with several nurses in the past. And I think that's important, when you're looking for an attorney. Have they dealt with nurses before? So, if you're in Indiana and you need to call Ryan, he works like we do. We are very, we practice law like nursing. We want to take care of our clients and potential clients and make sure that, we put them in the right direction or help them however we can. So Ryan, how can people reach you?
You can call us at 317-254-8500. We also have a website, fwslegal.com. That's Fox, Williams & Sink. Our phone consultations are free. However, once again, we do practice just in the state of Indiana. So individuals that work in the state, that's who normally our clients are. And we'll try to assist you in any questions that you have.
So whatever, if you feel like your job's in jeopardy or you're getting written up and you don't know how to handle it, you've got a great resource right here, and it's free. So he'd be happy to help. He's also very honest with what I found with my clients about whether they have a case or not, or whether he's willing to proceed further, because it's hard enough to be having action against you and knowing in the future you're going to have to at least put it on your license renewal and possibly appear before the board. And of course, in Indiana, we're very pro-employer, unfortunately, as well. But he will be very honest and upfront with you and help you figure out what your rights are. So I would definitely recommend him.
Thank you.
And grateful to have him. And he's great at sharing information, just like he has for you on this video. So until next time, enjoy. I hope you don't ever have to call Ryan. and that's what we both say. If we could do ourselves out of a job, that would be awesome, because as much as we like helping nurses, a lot of the things, unfortunately, shouldn't be happening, or we wouldn't be here. So until next time, we'll see you again. Thanks for watching. Bye.